It's a clearance sale on Clarence Thomas. According to a bombshell report from ProPublica, Supreme Court Justice Clarence Thomas has been secretly accepting gifts in the form of luxury vacation from billionaire Republican donor Harlan Crow and failed to disclose them for over 20 years. And a second ProPublica report revealed that one of Crow's companies purchased 2 vacant lots and a house from Thomas and his relatives in 2014, which Thomas also failed to disclose. Also, the home just happens to house one Leona Williams, Clarence Thomas's mom, who the billionaire donor has allowed to live there rent-free. And now a Washington Post investigation discovered that Thomas has for decades claimed income from a real estate company that no longer exists. The optics alone here are terrible. These luxury trips and real estate sales are potentially worth millions of dollars in benefits flowing from a conservative billionaire megadonor toward one of the 9 votes that have basically unchecked power over the whole US legal system. And Justice Thomas determined that he had no obligation to disclose any of this until he was caught. And frankly, upon examining the toothless ethics laws in place for our nation's top court and the apparent lack of political will to enforce the laws that we actually do have, Justice Thomas may be right. Now, before diving into the Clarence Thomas saga, let's talk about the key players here. First, we have the inheritor of a Dallas real estate fortune, Harlan Crow, who is a longtime megadonor to Republican candidates, causes, and organizations. Now, a few years after Justice Thomas joined the Supreme Court in 1991, Crow met Clarence Thomas and his wife, Ginny. And in the years that followed, they claimed to have become close friends, though importantly, in the years after he became a Supreme Court justice. Now, Crow is also a major donor to the Federalist Society, a conservative legal organization. Crow has publicly given more than $10 million in political contributions, and probably more via undisclosed dark money donations. But when asked about his contributions, Crow once told the New York Times that he, quote, does not disclose what I'm not required to disclose. Now, on April 6, 2023, ProPublica revealed that Clarence Thomas has accepted luxury trips nearly every year from Crow without listing them on his federal disclosure forms. In June of 2019, Justice Thomas and his wife Ginny flew on Crow's Bombardier Global 5000 jet to Indonesia, then boarded Crow's 162-foot super yacht for 9 days of island hopping. The total cost of the trip would have exceeded $500,000 had the Thomases chartered the plane and the fully staffed yacht themselves. According to the report, Thomas went on at least 6 trips on Crow's private jet, including to Indonesia, upstate New York, and New Haven, Connecticut. Thomas also traveled with Crow to the Bohemian Grove, an exclusive California all-male retreat, and visited Crow's ranch in East Texas. And 1 week per year, Thomas would vacation at Crow's private resort in the Adirondacks. And this is certainly much different from the more humble and down-to-earth image that Justice Thomas has attempted to cultivate over the years.
You know, I don't have any problem with going to Europe, but I prefer the United States. And I prefer seeing the regular parts of the United States. I prefer going across the rural areas. I prefer the RV parks. I prefer the Walmart parking lots to the beaches and things like that.
Yeah, sure. I'm sure that's the case. And just a week after the initial report on April 13th, ProPublica published details of an October 2014 real estate transaction between Crow and the Thomas family. According to public documents, one of Crow's companies paid just over $133,000 for 2 vacant lots and a single-family home that were co-owned by Thomas, his mother, and the family of Thomas's late brother. The transaction, which had not previously been disclosed, was the first known instance of money flowing directly from the Republican megadonor to a Supreme Court justice. Now, under the terms of the sale, Crow allowed Justice Thomas's then 85-year-old mother, Leona Williams, to live in her home for the rest of her life. She lives there currently rent-free, but is responsible for property taxes and insurance. And after the sale was completed, contractors then undertook extensive renovations of the house. Then, on top of those transactions, according to an April 16th article by the Washington Post, Thomas has reported hundreds of thousands of dollars of income from a firm called Ginger Limited Partnership for 2 decades. The problem here is that the real estate firm, founded by his wife and relatives, has not existed since 2006. The company's assets were taken over by a similarly named Ginger Holdings LLC, but Thomas's disclosure forms make no mention of a newer firm. Now, given the similarity of the names, it's possible that the company was just listed in error, but it merits mention given Thomas's decades-long history of non-disclosure. In a statement provided to ProPublica, Crow describes the Thomases as, quote, very dear friends, and defended the trips as the kind of hospitality he extends to all their close friends. Quote, we have been most fortunate to have a great life of many friends and financial success, and we've always placed a priority on spending time with our family and friends. With respect to the property purchase, Crow said he purchased the home with a plan to turn it into a public museum honoring Clarence Thomas. While he claimed the transaction was at market rate, Crow purchased a vacant lot and a house on the same block for $40,000 the prior year. Crow did not explain why he bought the two vacant lots, but indicated that they had been sold. Crow also asserted that he has never attempted to influence Justice Thomas on any legal or political issue, and claims he is unaware of any friends attempting to influence Thomas on the same. But at the same time, Crow serves on the board of multiple groups that have advocated at the Supreme Court through the filing of amicus briefs. And in 2005, a company called Trammell Crow Residential that was formed by Harlan Crow's father and partly owned by Harlan Crow was a defendant in a case before the Supreme Court. Clarence Thomas did not recuse himself from that case. In response to ProPublica's reporting, Clarence Thomas defended the trips and pleaded ignorance that it was wrong, and in a rare statement stated, quote, "Harlan and Kathy Crow are among our dearest friends, and we have been friends for over 25 years. As friends do, we have joined them on a number of family trips during the more than quarter century we have known them. Early in my tenure at the court, I sought guidance from my colleagues and others in the judiciary and was advised that this sort of personal hospitality from close personal friends who did not have business before the court was not reportable. I've endeavored to follow that counsel throughout my tenure and have always sought to comply with the disclosure guidelines. These guidelines are now being changed as the committee of the Judicial Conference responsible for financial disclosures for the entire federal judiciary just this past month announced new guidance, and it is, of course, my intent to follow this guidance in the future." Now, this statement raises far more questions than it answers. For example, while Thomas acknowledges being gifted family trips from Crow and perhaps others, he does not address the use of Crow's plane for other reasons, and as we'll talk about later, travel and the actual vacation itself are treated differently. For example, in 2016, Thomas used Crow's plane for a direct 3-hour trip to and from New Haven, Connecticut, which would have cost about $70,000. And it appears that Thomas might have been the only one on that plane. And obviously no one would ever vacation in New Haven, Connecticut, so the trip must have been for some other reason. Additionally, Thomas asserts that he sought guidance within the judiciary and was advised that his hospitality from close personal friends was not reportable. But Thomas doesn't specify who advised him, whether they had any expertise whatsoever, whether they were self-interested in that advice, whether this occurred before or after befriending Crow, or whether he followed up after this initial advice within the 30 years that this has been going on. And while Thomas claimed that he has always sought to comply with disclosure guidelines, the justice has a documented history of forgetting to disclose certain things. In 2011, Thomas amended prior forms to reflect income his wife earned between 1998 and 2003 from the Heritage Foundation, which is a conservative think tank, which Thomas claimed was inadvertently omitted. A 2004 LA Times report revealed that Thomas had accepted private plane trips and expensive gifts, including a Bible that was previously owned by Frederick Douglass, valued at $19,000, and a bust of Abraham Lincoln valued at $15,000. The article also noted that Crow had donated $175,000 for a new Clarence Thomas wing at the Justice's Childhood Library in Georgia. And after the Times report, Thomas continued to take plane trips from Crow. He just stopped disclosing them. And ProPublica is not the first publication to raise questions about the relationship between Crow and the Thomas family. In 2011, the New York Times detailed numerous favors that the Texas billionaire had done for the Thomases, including helping to finance a library dedicated to the Justice in Savannah, Georgia, and providing $500,000 for Ginny Thomas to start a Tea Party conservative activism group, which came with a $120,000 a year salary for Ginny Thomas. And in a move that stirred controversy at the time, Crow financed a multi-million-dollar restoration of a cannery that included a museum about the culture and history of Pinpoint, Georgia, a pet project of the Associate Justice. Now, Crow says he hasn't tried to influence Thomas on any issue, and it's true that people who are ideologically aligned are probably more likely to become friends. But if a billionaire gave my partner $500,000 to start a political organization, flew us around the world on a private jet, bought property from me that would both house my mother for the rest of her life, and promised to have that house turned into a museum honoring me, well, you might question the independence of this channel. Harlan, call me. Now, Thomas's former law clerk, James Ho, who currently sits on the Fifth Circuit Court of Appeals, defended his former boss by suggesting that the hypocritical double standards were at play, saying that, quote, "there's a big difference between actual corruption and the appearance of corruption." But even if there isn't any quid pro quo between Crow and Thomas, the entire crux of judicial ethics is based on avoiding any appearance of impropriety. But under 28 U.S. Code Section 455, any federal judge, including these Supreme Court justices, are supposed to recuse themselves from any proceeding, quote, "in which his or her impartiality might reasonably be questioned." Unfortunately, there are neither official rules nor a legal mechanism to force the justices to recuse themselves, and Chief Justice Roberts has long resisted calls to impose a code of ethics on the Supreme Court. And not surprisingly, there is a wide-ranging debate on this topic. Multiple legal experts told ProPublica that these non-disclosures were not just unethical, but may have broken the law, specifically the Ethics in Government Act of 1978. And in a bit of cheekiness from Congress, the Congressional Research Service put out a helpful explanatory explainer of this law following, quote, a recent article detailing undisclosed trips by an associate justice. Whoever that could be. Of course, as you may know, finding a great lawyer can be hard. That is, until now. My firm, the Eagle team, is now accepting new clients. If you've been injured in a car accident, medical malpractice, or just about anything, or you just need a lawyer, we can help represent you or find you the right attorney. Because you don't need a legal team, you need the Eagle team. Just check out the link in the description. Now back to Clarence Thomas's shenanigans. Now, the Ethics in Government Act, or EIGA, was passed in the aftermath of Watergate, in part to, quote, preserve and promote the integrity of public officials and institutions. To achieve this goal, EIGA established financial reporting requirements for many high-level government officials and employees, including Supreme Court justices. The Judicial Conference of the United States, the principal policy-making body for the federal courts, has authority under the EIGA to administer the financial disclosure requirements for judicial officers and employees. And under EIGA, the Attorney General is authorized to bring enforcement actions against any individuals who violate the law's disclosure requirements. Those who knowingly and willfully fail to file or report any required information face fines of up to $71,000 per omission, adjusted for inflation. And in addition, those who knowingly and willfully falsify information can face fines and up to a year in prison. Now, some have argued that Thomas did knowingly and willfully violate these statutes. Under the pertinent rules, disclosures must include the, quote, identity of the source and a brief description and the value of all gifts, while the Judicial Conference filing instructions say that all gifts over $415 must be disclosed. In addition, the failure to disclose the $133,000 sale of property from the Thomas family to Crow could also be a violation. Justices are required to report a brief description, the date and category of value of any purchase, sale, or exchange which exceeds $1,000 in real property. Now, there is a personal hospitality exemption to disclosure, which provides that any food, lodging, or entertainment received as personal hospitality of an individual need not be reported, but it's likely that parts of these trips might not fall under that exception. The Act defines personal hospitality as hospitality extended for a non-business purpose by an individual, not a corporation or organization, at the personal residence of that individual or the individual's family, or on property or facilities owned by that individual or the individual's family. Yacht and air travel are not food, lodging, or entertainment, and it seems that disclosure should have been required under the relevant acts. Though in March of 2023, the Judicial Conference clarified the contours of this exception, which the authors argue reinforced this reading. Quote, the personal hospitality gift reporting exemption applies only to food, lodging, or entertainment, and the reporting exemption does not include gifts other than food, lodging, or entertainment, such as transportation that substitutes for commercial transportation. Though a good lawyer would argue that if you have to clarify it, that's not the interpretation that existed before the clarification. And as luck would have it, we do have a fairly recent prosecution for failure to disclose under EIGA. In March of 2022, a federal judge ordered ex-Apprentice star turned Trump aide Omarosa Manigault Newman to pay $61,585 in civil penalties for knowingly and willfully violating EIGA for her acrimonious firing in 2017. In his 15-page opinion, Judge Richard Leon of the DC District Court found that Omarosa had received countless reminders from administration attorneys of her legal obligation to file a termination report financial disclosure within 30 days of being fired. And those arguing that Thomas knowingly and willfully failed to disclose past gifts point to the fact that in 1997, Thomas disclosed that Crow flew him to the Bohemian Grove on a private plane. That travel, along with Crow's history of lavishing Thomas with gifts, was reported by the LA Times in 2004, which drew lots of criticism. But for the next 20 years, Thomas apparently decided to keep accepting flights from Crow, but just didn't report it anymore. So Thomas's statement that he received advice telling him that he didn't have to report plane and yacht trips doesn't really comport with the fact that he used to disclose this information, but then chose not to. Now, many observers have unfavorably compared Thomas's example to that of Justice Abe Fortas, who ended up resigning from the Supreme Court in 1969 after his own payment scandal. In 1968, LBJ nominated Justice Fortas to succeed Earl Warren as the Chief Justice. But an investigation revealed that Fortas had been paid $15,000 to be an adjunct professor at American University. But funding came from some of Fortas's old firm and clients, some of which came before the court. Fortas would later request to withdraw his nomination, but opted to stay on the court. But in 1969, it was revealed that Fortas took a $20,000 retainer from the family foundation of an indicted securities swindler, Lewis Wolfson. President Nixon, hoping to fill a liberal Supreme Court seat with a conservative, began leaking information to the press to pressure Fortas to resign. Now, Fortas's conduct was not technically illegal at the time, but Chief Justice and Fortas's friend, Justice Justice Hugo Black urged Fortas to resign to protect the integrity of the court. Reluctantly, Fortas resigned, and Republican Nixon got his wish. But don't expect Clarence Thomas to resign anytime soon. But the question remains, who can launch an investigation into the Supreme Court? Well, by law, the DOJ may initiate an investigation on its own or at the request of the Judicial Conference. Democratic Senator Sheldon Whitehouse of Rhode Island and Representative Hank Johnson of Georgia have sent a letter requesting the Judicial Conference investigate, writing, quote, "There is at least reasonable cause to believe that Justice Thomas intentionally disregarded the disclosure requirement by not reporting the 2014 property sales to Crow." But there's not a lot of examples of the Judicial Conference making such referrals, nor the DOJ prosecuting them. In 2014, the Judicial Conference referred Judge Boyce Martin, a Carter appointee to the Sixth Circuit, to the DOJ's Public Integrity Unit to investigate allegations of improper travel reimbursements. But the department decided not to pursue charges after Judge Martin, who had retired in 2013, voluntarily repaid the $138,000 he had received as travel reimbursements during the contested 4-year period, even though he said only a fraction had been challenged. Okay, it's Devin from the future, and there's been a lot of new developments. So much so that I moved things around in my set, so it looks slightly different now. Now, Clarence Thomas has not denied any of the facts in the ProPublica article, and Thomas's defenders assert that the whole story is nothing more than a smear campaign by bitter Democrats. Though it should be noted that some of Thomas's public defenders have also accepted money and fancy trips from Harlan Crow. For example, over at the National Review, lawyer Mark Paoletta wrote a story with the following headline: "Justice Thomas acted properly and was not required to disclose his trips." Seems totally legit. Though I should warn you that the article includes a world-class disclaimer. Full disclosure, I worked on Justice Thomas's confirmation as a lawyer in the White House in 1991. I have co-edited a book on him titled Created Equal, Clarence Thomas in His Own Words, and remain close friends with him. I have also represented Ginny Thomas in the January 6th committee inquiry. Now, a disclaimer to the disclaimer, this doesn't even tell the full story of his relationship with Thomas and Crow. Paoletta worked on the confirmations of Justices Thomas, Gorsuch, and Kavanaugh, and oh yeah, he was also a guest with Harlan Crow on the very same trips as Thomas himself. Here he is with Justice Thomas at Camp Topridge in the painting commemorating one of those vacations. Truly a masterful painting that really captures the essence of the photograph, which was also taken of the exact same spot. And it also captures the delicate light reflecting off of Harlan Crow's calves. But Paoletta's argument is that Thomas wasn't required to disclose the vacations because the personal hospitality requirement is brand new. And in an equally baffling follow-up piece, Paoletta addresses the sale of the house that Thomas's mother lived in. The crux of the argument is this, quote, "In the years preceding this transaction, Justice Thomas and his wife put significant sums of money into making improvements to his mother's house. Given these costs, their 1/3 share of its sale price amounted to a capital loss on the property. Because of that, Justice Thomas did not believe that the sale of his mother's home was a reportable transaction." This is, without exaggeration, insane. The relevant statute, as you've seen, requires disclosure of, quote, "any sale which exceeds $1,000 in real property other than the property used solely as a personal residence of the reporting individual or the individual's spouse." It makes no distinction between whether the sale was for a profit or loss. It kind of makes you question Thomas's ability to understand, the law. Meanwhile, Justice John Roberts turned down a request to testify in front of the Senate about the unreported gifts, travel, and real estate transactions. Instead, he sent a letter stating that the justices are all ethical. All 9 justices signed a document attached to the letter entitled Statement of Ethics, Principles, and Practices. Roberts suggested that there was a separation of powers issue with asking the Chief Justice to appear before the Senate. He points out that only 2 justices and 3 presidents have ever done so. Though it does make one wonder what kind of checks and balances there are if the Supreme Court can't be forced to testify in the face of potentially huge corruption. And as the Chief Justice acknowledges, testimony of justices and presidents is rare but not unheard of. The 2 justices who testified to Congress in the past were questioned about administrative matters. So the Chief Justice implies that it's fine to go to the Senate to talk about minor issues, but it's somehow beyond the pale for the Chief Judge to address serious ethical issues. Now, obviously the justices fear additional embarrassing disclosures. For example, 9 days after his confirmation, Justice Neil Gorsuch sold a property that had languished on the market for 2 years. He disclosed the sale, but left the buyer section blank. The buyer turned out to be the leader of a law firm with, surprise, many cases in front of the Supreme Court. Now, these accusations have come out against Clarence Thomas, but they'd be astounding if any justice had committed them. And of course, these are only the facts that we know about. For all we know, Justice Sotomayor might be being flown around the world by Bill Gates, and Kagan is getting hundreds of thousands of dollars of vacations from Larry Ellison. And all of that would be super bad. But the lack of ethics or enforcement is a real problem with no easy solution. There are real separation of powers issues, and the Supreme Court interprets the law. And also Congress is pretty much deadlocked on everything, so it's not likely that any of this is likely to change anytime soon. And Paoletta stepped up again to defend Thomas when reports came out that Crow paid for the private schooling of his grandnephew. Reports state that Thomas took on his grandnephew, became his guardian, and raised him as a son. All extremely laudable things. But he didn't disclose that Crow had paid over $150,000 for the boy's private school tuition. This time, though, Paoletta seems to have a better defense for Thomas. Paoletta argues, and I think he's right this time, that the relevant statute requires disclosure of gifts for dependent children, but defines dependent children as a son, daughter, stepson, or stepdaughter, and who is a dependent defined by the IRS. No idea why the statute is written that way, but it seems true that Thomas's grandnephew is not a son, daughter, stepson, or stepdaughter, and thus this particular incident wouldn't need to be reported. There are reports that Justice Sonia Sotomayor was paid $3.6 million for her various book deals, but declined to recuse herself from multiple copyright infringement cases involving book publishers or their parents or subsidiaries. Now, that's bad too, but at least she disclosed those issues where Thomas seems to have hidden his incidents completely. Of course, the justices really enjoy their privacy. So if you'd like to be as private as a Supreme Court justice, you can get your online personal data taken down with today's sponsor, Incogni. Now, I don't know about you, but I've seen a huge uptick in the amount of spam that I'm getting. And it's no surprise. Every year, the number and scope of data breaches worldwide is rising. And you might not know it, but there are hundreds of data brokers that possess and sell your personal data, probably right now, and their numbers are growing every year. These data brokers could have your name, your address, phone number, shopping habits, possibly even your social security number, all up for the highest bidder. I know when I checked, there were literally hundreds of different companies that had this information. At best, this leads to scam calls, and at the worst, identity theft and doxing. But here's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them your approval to work on your behalf. Incogni conducts repeated, ongoing removals because even if the broker removes your data once, they could collect it again. Incogni makes sure that your personal information stays off the market for good. When I signed up, I saw a huge decrease in the number of spam emails and calls that I was getting. And it was terrifying to see exactly how many brokers have our data, and it's really fun to watch Incogni get them to delete that info one by one. If they fight, Incogni will actually fight back and send repeated letters on your behalf until that information is gone. So if you'd like to give Incogni a try, click on the link below to get 60% off of Incogni when you use the code LegalEagle. Again, to get 60% off, just click on the link that's on screen right now or down in the description and use the code LegalEagle. And after that, click on this box over here for more LegalEagle, or I'll see you in court.